International comparative and foreign law issues are all around us in an increasingly globalized world. Even seemingly cloistered areas of practice, such as estate planning, often encounter issues of foreign or international law that bear directly on strategy or even resolution of contentious issues. I'm Regina Jeffries, teaching fellow at UNSW and instructor in Law in the Global Context Legal Research and Writing program. And I'm joined here today with Professor Goodwin-Gill, professor of law at UNSW, the acting director of the Andrew and Renata Calder Center for International Refugee Law, and a barrister at Blackstone Chambers in London. Thanks, Guy, so much for joining us today. So, Guy, I wanted to talk a little bit about some of the practicalities and the crossover of international and domestic law practice, and to shed a little bit of light on the realities of an area of law that's often depicted as sort of flashy and James Bondish in the news and media. We often hear discussions of international law that seem to be primarily confined to the foreign policy arms of states. So the practice seems pretty remote from daily life or what most people might expect in the day-to-day practice of law. Has that been your experience with it?
Not at all, not at all. I think perhaps when I first got into international law, it did seem to be rather ethereal. It seemed to be something which, governed the distant relations of states amongst themselves. But the more I became involved in the practice of law generally, the more it became clear to me that international law is there at every turn, in fact. Whatever we do these days, it is quite likely that there has an international treaty or an international law which has some bearing on that. And it's the challenge of bringing the international legal dimension into the domestic, which I think really appeals to me. I don't know that it's James Bondish, but it has an excitement about it which has never left me.
And what drew you to international law practice?
The rest of law which I didn't like. No, when I was studying law as an undergraduate, I ploughed my way through it. I had no intention at that time of becoming a lawyer. But there were two subject areas that did appeal to me: constitutional, public law, and then in my third year, international law, and that really excited me. And as soon as I'd completed my degree, I wanted to do postgraduate work in that field.
And how did you ultimately enter into practice then?
I qualified as a barrister very early on, again, with no actual intention of practicing, but because it was there and it was sort of expected. And I qualified as a barrister in the UK in 1971, but I never actually went into practice until the early 2000s. And the reason for that was, well, in the first part, I was an academic, and the secondly, I was working for the United Nations High Commissioner for Refugees. But then when I got back into academic life, I found myself being asked for opinions on this or that, writing those opinions, and then seeing them, as it were, misused, seeing them used in a way which I thought was not the best. I thought, I can do this. So I went and did what we call in the UK pupillage, which is a sort of apprenticeship. I got a few months off for old age, and then started practicing in the international field, and thoroughly enjoyed it too.
And so what types of matters have you handled over the course of your career?
My very first court appearance, disastrous by the way, was in the Wolverhampton Magistrates Court, seeking an adjournment on a VAT application. I didn't get it. It was tangentially related to my area of interest because it was an application by a company which ran accommodation for asylum seekers. But then after that, things began to take off. I found myself acting pro bono for the Office of the UN High Commissioner for Refugees as an intervener, and very soon I was in what was then the UK's Supreme Court, the House of Lords, on a case known as the Roma rights case. And that was a fascinating and exciting experience, to be suddenly launched into the highest court of the land, arguing for the UN what ought to be the right interpretation of international law as applied by the UK.
Very nice. And so what would you say that your most interesting or challenging case to date has been?
I think in court, certainly that first case, the Roma rights case, was one of them. But then a case which nearly got into the House of Lords but was settled by the government, known as Al-Rawi, which was a fascinating case. It involved British recognized refugees who had been swept up in various countries in the world and detained in Guantanamo, often after being beaten up and tortured in various places. And the British government wanted nothing to do with them. It said, no, we can't intervene because they're not our citizens. And as you know, under the practice, the rules of diplomatic protection, there is the nationality requirement. But we, in acting, as I was again on the part of UNHCR, we argued you don't need citizenship because both the UK and the US are party to the same treaty, the 1967 protocol. So there's a treaty base for intervention. And putting that argument together and getting it into court was, I think, was exciting. And even though we lost in the Court of Appeal, we were going to appeal to the House of Lords, but then the government settled and said, all right, we will intervene and we will readmit these individuals individuals whom we have recognized as refugees. We'll let them back into the UK without doing any prior security clearance. That was exciting. That was good. It took a long time, and the situation wasn't eventually settled for some time, but that was very satisfying.
A bit more successful than the first foray into court.
Yes, I think so, certainly. Even though we didn't get the ruling, but as we know, governments love to settle. They don't want to get the courts ruling against them. We see that all throughout the world, which is sad in many respects. I think it would be nice to have a rule which allowed courts to rule regardless of whether a party wants to settle, simply so we can have a point of law established once and for all.
So I heard a rumor that you might have been somewhat involved in the Julian Assange case.
That is indeed the case, but then I think, at the last count, more than 105 lawyers had been involved at various times in the Julian Assange case. Yes, no, I was. I suppose I could count him count myself as a member of his legal team at some time or other. I met him in the Ecuadorian embassy at one stage of the discussions about what to do. I put in my proposals for resolving the situation. They weren't accepted. Whether that's the reason why things continue as they do, I have no idea. But I thought I had a good legal argument there. But unfortunately, what we've seen in that case is two intransigent parties, for understandable reasons. I mean, the United Kingdom, as is the case with many countries, resists the whole idea of diplomatic asylum. The Latin Americans are wedded to that idea. And I think there were elements in the government of Ecuador that wanted to export the idea, the notion of diplomatic protection, diplomatic asylum rather, to the rest of the world. And that's the issue of intransigence. Both sides had positions were very clearly understood, and there was very little that could be done to break that, apart from the suggestion that I made to them.
Which obviously should have been. Well, along those lines, have you consulted on international aspects of domestic law matters as well in the course of your career?
Yeah, I've been asked, for example, very often on opinions whether legislation or proposed legislation did meet the requirements of international law, particularly in the context of refugee and migration. In Canada a few years ago, back in the late 1980s, early 1990s, when they were talking about introducing provisions on the interception of boats, yes, as long ago as that, I gave advice on where and how that might be lawful or unlawful. It eventually faded away as an issue, but I like to think that my suggestions there might have influenced the Canadian government of the day to adopt a more understanding approach to what was required as a matter of international law. Whether governments ask me, generally, no, I think they don't, because they probably know what my position is on these sorts of sensitive issues. I have been asked on other, as it were, less controversial issues, like, for example, the capacity of certain entities to make treaties independently, sub-state entities, for example, whether they have the capacity to conclude tax agreements and the like. I've been asked to advise on fisheries jurisdiction, but not so much otherwise on controversial issues touching on domestic policy.
And how do those matters typically reach you? Through referral or...
Yeah, I mean, as a barrister in the United Kingdom, we are all self-employed, but we get together in what are known as sets of chambers. I'm a member of Blackstone Chambers in London, and we have clerks there who basically look for business or promote the capacity and the competences of the members of that set in certain areas of law. And then one gets a name, and it filters through, and the work comes in. So it's generally in that way. We don't, as it were, go out and tout for business. It's a bit reactive in many respects. And in the UK, as you may know, they've had for a long time a principle that they call the taxi rank rule, that in effect means that if you hold yourself out as competent to practice in a particular area of law, you take what comes. You don't get to pick and choose, for example, to decide that you only want to work for those challenging government actions. If government work comes your way, then you're expected to take it, if you're free, of course. And I think that's a pretty healthy approach in many respects, and I've had to do that too.
Okay, and so what would you say that some of the most important skills are for students to develop in preparing for a career practicing law with all of these international and comparative and foreign law issues that might come up?
I think it's to find out where your heart is. I mean, that's where I've been particularly fortunate, and I've been able to work in an area of law which still gets me angry. I still get engaged in these issues. We can't guarantee that as being what is available to everyone who studies the law, but I think it's important to have interest in what one's doing. And if one has an interest in civil rights, in human rights, in international law, then I'm certainly confident that one is going to be forever motivated to take action, and not necessarily in a confrontational way with government, because there are so many other ways of dealing with these issues and promoting the needs. But what you need particularly as a lawyer, for example, concerned with human rights or refugee rights, is a deep knowledge of international law itself. And I often am regretful when I come across committed human rights lawyers who actually don't really know enough about how the international legal system works. So a good basic grounding in international law, how treaties are made, how customary law comes about, and so forth, I think is an essential precursor to a detailed study of the particular subject area.
Very good. Well, thank you so much for joining us. It's been wonderful to have you.
My pleasure. Thank you very much, Regina.